International Convention on the Protection of the Rights of All Migrants Workers and Members of Their Families, Scope and Key Terms. Part 1, Scope and Definitions, Article 1. The present convention is applicable, except as otherwise provided hereafter, to all migrant workers and members of their families without distinction of any kind such as sex, race, color, language, religion or conviction, political or other opinion, national, ethnic or social origin, nationality, age, economic position, property, marital status, birth or other status. 2. The present convention shall apply during the entire migration process of migrant workers and members of their families, which comprises preparation for migration, departure, transit and the entire period of stay and remunerated activity in the state of employment as well as return to the state of origin or the state of habitual residence. Article 2, for the purposes of the present convention. 1. The term migrant worker refers to a person who is to be engaged, is engaged or has been engaged in a remunerated activity in a state of which he or she is not a national. 2. A. The term frontier worker refers to a migrant worker who retains his or her habitual residence in a neighboring state to which he or she normally returns every day or at least once a week. B. The term seasonal worker refers to a migrant worker whose work by its character is dependent on seasonal conditions and is performed only during part of the year. C. The term seafarer, which includes a fisherman, refers to a migrant worker employed on board a vessel registered in a state of which he or she is not a national. D. The term worker on an offshore installation refers to a migrant worker employed on an offshore installation that is under the jurisdiction of a state of which he or she is not a national. E. The term itinerant worker refers to a migrant worker who, having his or her habitual residence in one state, has to travel to another state or states for short periods, owing to the nature of his or her occupation. F. The term project-tied worker refers to a migrant worker admitted to a state of employment for a defined period to work solely on a specific project being carried out in that state by his or her employer. G. The term specified employment worker refers to a migrant worker who has been sent by his or her employer for a restricted and defined period of time to a state of employment to undertake a specific assignment or duty, or 2. Who engages for a restricted and defined period of time in work that requires professional, commercial, technical or other highly specialized skill, or 3. Who, upon the request of his or her employer in the state of employment, engages for a restricted and defined period of time in work whose nature is transitory or brief, and who is required to depart from the state of employment either at the expiration of his or her authorized period of stay, or earlier if he or she no longer undertakes that specific assignment or duty or engages in that work. H. The term self-employed worker refers to a migrant worker who is engaged in a remunerated activity otherwise than under a contract of employment and who earns his or her living through this activity, normally working alone or together with members of his or her family, and to any other migrant worker recognized as self-employed by applicable legislation of the state of employment or bilateral or multilateral agreements. Article 3. The present convention shall not apply to a. Persons sent or employed by international organizations and agencies or persons sent or employed by a state outside its territory to perform official functions, whose admission and status are regulated by general international law or by specific international agreements or conventions. B. Persons sent or employed by a state or on its behalf outside its territory who participate in development programs and other cooperation programs, whose admission and status are regulated by agreement with the state of employment and who, in accordance with that agreement, are not considered migrant workers. C. Persons taking up residence in a state different from their state of origin as investors. D. Refugees and stateless persons, unless such application is provided for in the relevant national legislation of, or international instruments in force for, the state party concerned. E. Students and trainees. F. Seafarers and workers on an offshore installation who have not been admitted to take up residence and engage in a remunerated activity in the state of employment. Article 4. For the purposes of the present convention, the term members of the family refers to persons married to migrant workers or having with them a relationship that, according to applicable law, produces effects equivalent to marriage, as well as their dependent children and other dependent persons who are recognized as members of the family by applicable legislation or applicable bilateral or multilateral agreements between the states concerned. Article 5. For the purposes of the present convention, migrant workers and members of their families a. Are considered as documented or in a regular situation if they are authorized to enter, to stay and to engage in a remunerated activity in the state of employment pursuant to the law of that state and to international agreements to which that state is a party. b. Are considered as non-documented or in an irregular situation if they do not comply with the conditions provided for in subparagraph a of the present article. Article 6. For the purposes of the present convention. a. The term state of origin means the state of which the person concerned is a national. b. The term state of employment means a state where the migrant worker is to be engaged, is engaged or has been engaged in a remunerated activity, as the case may be. c. The term state of transit means any state through which the person concerned passes on any journey to the state of employment or from the state of employment to the state of origin or the state of habitual residence.